everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed, Trial 2.0, and we are on day 5. We're going to do a quick recap of day 5, which is Monday, April 28th, and it was a half day of testimony and then a half day of voir dire with the ARCA experts. So let's get into it. Please hit that like button and let's get started. All right, so Ian Whiffen was the first witness of the day. He was called by the Commonwealth for the state's case. He is the digital forensics examiner and the decoding product manager for Cellbrite. Cellbrite is pretty much the golden standard of, uh, data, digital forensics examining tools. One of the, anyways. And so that is where he works. He says Cellbrite provides digital forensic solutions to customers for decoding digital artifacts from devices. Cellbrite mostly focuses, excuse me, Cellbrite mostly focuses on iPhones or phones and like iPads, or tablets, but some computers. So, not as much for the computers, but mostly phones and tablets, iPads, whatnots. All right, so the Cellbrite creates its own software to analyze data. They have their own proprietary software. He says he served as a frontline police officer in the UK and in Canada. He joined digital forensics team in 2013. Excuse me, I cannot clear my throat for some reason. Sorry. Okay. That's not any better. I drank some water, but it didn't help. um, it says he said in 2019 and in 2020 he left the police force to go work for Cellbrite. So basically, the majority of his work experience is law enforcement. He teaches webinars and he writes blogs about this stuff. He sometimes has peer-reviewed papers. He does his own research. He created his own tools that he claims their vendor doesn't offer, that it has functions that the vendor that he works for doesn't offer, or that Cellbrite doesn't offer. So he's been admitted as an expert at least 20 times, he says. Software makes data easier to interpret, creates a report, but an examiner is needed to review and interpret that data. So that's what the software does. It helps make it pulls all of the information and then it allows the examiner to redefine the parameters of how they want to look at things, and then they can search for things in different ways and interpret the data however they interpret it. He says he was contacted by troopers to analyze data in this case. Customer service received a call. So Cellbrite's customer service received a call from a Richard Green, who is an independent forensic examiner. He happens to be the examiner for the defense. And he says that Richard Green was asking a question about a timestamp in this case. That timestamp is a time attributed to an artifact that shows when something happened, or a timestamp is a time that was supposed to be not a plus sign, an equals sign. That's why I confused myself. Oh, now where is it? Okay, here. So a timestamp, I did it again. The timestamp equals the time that's attributed to an artifact. So it shows when something happens on a device, is what he said. An artifact is a piece of any of data. It's a piece of data that's pulled from a device. It could be a text message, a location point, or photo, for example. More information in the background that all forensic examiners can use to validate artifacts. They have to, go into the background information and dig to find, things to analyze. Richard Green, Karen Reed's forensic examiner, wanted to know when a timestamp occurred in relation to when an internet search was made. The troopers that uh, uh, also the troopers also inquired about this particular timestamp. And I said, in my mind, "Well, what was that conversation like? Like, did the troopers go to them and say, can you tell us about this 2:27 a.m. timestamp? Or was it how did that conversation come up? Did Whiffen have to go to the troopers and say there's an issue here? Or what happened? How did that whole conversation happen? And what was said? I'd love to know. Anyways, so Whiffen didn't know about Green's question until months later, he says. So the call came in on customer service, and then Ian Whiffen didn't learn about it until months later. The timestamp of 2:27:40 a.m. Whiffen says there was no other information on the device that suggested that internet query had occurred at that time. I call BS, but that's what he said on the stand under oath. He said he recreated a test data and he discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance as to when the actual web query was made. So a tab can come into focus when you pull up your Safari and the tab that's already, your last tab that was viewed comes into view, or you close that tab and then another tab comes into view, the one that was behind that. So that's when a tab comes into focus, he explained. um he said that this is relatively, did I miss something? Hold on. Yeah, okay, so he recreated that. He discovered that it was actually the timestamp when it came into focus, and not when she searched that term, but when the tab came into focus, which makes absolutely no sense. He says that this is a relatively common question because one other person asked about the same thing. So again, he's saying it's relatively common because two people in the history of Cellbrite have had this question. Just saying. Common now because two people asked a question about a timestamp. When in reality, he was trying to verify that it did happen at that time, and law enforcement was like, "Oh no, we can't have it say that." At least allegedly, in my opinion, that's what I think happened. So he says that this is relatively common. He received and analyzed data in Jen McCabe's phone and John O'Keefe's phones. He created a PowerPoint to walk through a demonstration, and then the witness went through a bunch of stuff in his presentation. I'm going to go through, I'm not going to, I brought up some of his, as you'll see, you can go and look for some of the presentation. I took screenshots and gave you kind of like what was on the screen, what they're talking about, so you have more of an idea. But here I kind of just go through the highlights of his PowerPoint. So up first, he says there's two versions of, well, there's multiple versions of iOS, but in this case, the two versions that he paid attention to were iOS 14 and iOS 15. I believe John McCabe's is iOS 15. But he says, so regarding iOS 14, in the past, this is, the past version of iOS, the tabs on your phone would, this is iPhone, so iOS is the internet operating system for iPhone. So it says that the tabs on the phone, he said that the tabs on the phone in your internet browser will stay open indefinitely until you close them. Each tab will have its own timestamp. He explains that when a tab is first open, a row is created in the iOS database showing the timestamp, the URL, and the title of the web page. He then says that when a new search is made, the first record created is no longer active and a new row is then added to the database. He showed it in like a table. So he showed it in like a table format. So the first row was the first search, second row would be the second search. So the first row is no longer active, and then a new row is added to the database with a new timestamp, URL, and title of the web page. This new data doesn't overwrite the old data in this version. The old data is still recoverable. This action will repeat with each new web search on that tab. And you can go back and see apparently every single search and timestamp throughout in this version. He says he needs a forensic tool to see the old versions. It's not visible in the regular database. Moving on to iOS 15, he says that this process changed with the new version of iOS, which is the version of whoa, sorry. That's the version. I talk too much with my hands. He says it's the version of Jen's phone where he so Jen's phone is iOS 15, and this means she has this newer version where the process apparently changed. He claims that the data is not written into the database immediately as it used to do in iOS 14. Instead, it only writes the timestamp when you close out of the tab or the tab goes into like a suspended state. So the browser state DB is the name of the iOS database that um, uh, he refers to frequently. So they asked him what was that. He says that the data, the time, so there's lots of databases within your iOS system, and the browser state DB is like, I guess, the main one. Then there's like a bunch of other ones. There's like history and mobile stuff. So there's all sorts of different databases where information is stored and you can parse it to find info, hence the examiner to go through and look for it. All right, so he says that the data, the timestamp, the URL, the web page, they don't get written into the database until you close the tab, and the only data written is the last search, not the data for the previous searches. Like I said, the in in his table, he had all rows visible of every single search made on that tab. Well, that's not so in this new format, he says, and it overwrites the last or it overwrites all of the previous information but you get the timestamp from when the tab is opened and then the page when it's closed. It makes no sense to me, but he's gonna die on that hill. I said, go for it, buddy. It's your reputation. So, yeah, that's what he's going with. Jen McCabe's phone activity. And I just want to say that I had to slow down his testimony like a lot and repeat it over and over and over again to get you guys these notes. Otherwise, I wouldn't have had these notes as detailed as they are. So for the jury, they're not going to have all this and they're going to be very confused by his testimony. FYI, I was confused by the testimony and I was taking notes and following along as best I could. All right, so for now, he's going to go into the analysis that he has of Jennifer McCabe's phone. He says that he used multiple databases on the device to search for Jen's history on her Safari. So there was these are the main databases that he looked at: the browser state DB, history DB, Mobile Safari DB, and the Knowledge C DB. He says that there were multiple tabs open on Jen's phone at 2:27 a.m. He says a tab for Hakamak Sports was logged at 1:59. This is a lot of timeline, so I'm just going to be repeating. It's going to be kind of cut and dry, and I'm going to try to get through it as quickly as I can. He says a tab for Hockomock Sports was logged at 1:59:44 a.m., closed sometime thereafter, but was no log of when it was closed. He says there was a browser switch at 2:27:31, and the last visited timestamp, which he says was PayPal, was logged. Says there was no navigational event in this history. He then says the PayPal tab gets closed at approximately 2:27:32 a.m., causing it to be written into the database. Then at 2:27:33, another tab is brought into focus from the background for Eastern Bank, last visited January 27th at 8:02 a.m. Then that tab gets closed and written into the database. An older tab from January 27th. Keep this in mind because Gemma Cabe is going to testify on day 6, and she's going to talk about the It's Raining Men video, and she says that she's actively viewing it on her phone on the 28th, when in reality it's an older tab from the 27th on her YouTube video, or on her phone for a YouTube video of It's Raining Men, the music video for It's Raining Men. I don't know. Um, she says or he says that tab, this older tab, loads and comes into focus from the background. Then there's another tab switch at 2:27:36, and this is recorded, and it's Hockomock Sports. This comes into focus. No navigational event at this time. This tab is then closed. So she doesn't, search for anything, just closes the tab. Then the next focus goes back to the It's Raining Men tab at 2:27:38 a.m. This tab is closed milliseconds after it's opened. Another tab switch occurs at 2:27:40 with Ozone Basketball tab. Says this is the tab that was ultimately used. He said this, but then they start talking about the Hockomock Sport, so I don't know. Maybe I missed something in my notes here, but he says this was the tab that was ultimately used for the search, but it wasn't because it was the Hockomock Sports, is what I believe. But anywho, um, so I believe there was an inconsistency in his testimony from how I took the notes. Um, if I took them correctly, assuming that I did not make a mistake. All right, so another tab switch occurs at 2:27:40 with the Ozone Basketball. Sorry, I read that. Then a web navigation occurs at 2:27:42, and Hockomock Sports standings is opened. So, it's Hockomock Sports. Then the next page in the line is standings, like the standings, the scores of uh, the um the teams. Then another web navigation occurs at 2:27:47 for Hockomock schedules. Another web navigation event occurs at 2:27:53 for Hockomock schedules girls hockey. Then another one for all those things. Then Franklin 2021-2022. So Hockomock schedules girls hockey, Franklin 2021-2022. There was no tab switch during the Hockomock searches. At 2:28:06, Safari tabs are minimized or in the background, not being used again until 6:23:37. The last tab used was the Hockomock schedules girls hockey Franklin 2021 to 2022. This comes into focus at that time, the 6:23, and then at 2 milliseconds later, she searches in Safari how long to digest food. That was a Safari suggested search, so it came up like as she started typing, and she accidentally hit, the first thing that appeared with her finger. At 6:23:51, there's a Safari search for how long tea die in sicht. That's the second misspelling of the search history. There's no history record made here, he says, suggesting that it never successfully or completely loaded. That's what he was going with. That was his excuse as to why it didn't appear, or why it appears as deleted in her log, in her data extraction. Then at 6:24:18 is the actual cover up, House Long to Diane Cold. She spelled it the wrong way this time. She spelled it incorrectly the correct way because that's how she was supposed to spell it to cover for her 2:27 a.m. Now the page is minimized or put in the background at 6:24:24 and reopened at 10:33 a.m. A previous search is shown for the house long to die in cold, but the witness says there's no event that shows the page fully loaded. Then around 10:33:34, the tab was closed, causing it to be written into the database. The timestamp of 2:27:40 is logged. Does this make sense to anybody? No, it doesn't make sense. He says the timestamp of 2:27:40 is logged, even though it's closed at 10:33:34. He says all it records is the most recent page that was visited along with the time the tab came into focus, meaning the tab came into focus at 2:27 with the Hockomock Sports, but it didn't log Hockomock Sports. It logs the most recent web page, even though the web page allegedly was last viewed at 10:33. If any of that makes any sense. I say, why would the software record data that is misleading and incomplete? It just doesn't make any sense that it would do this way. So I think that's woohoo crazy. All right. So he also says that the history database in Jen's phone did not indicate either the 623 or the 624 searches. And the witness says there was no missing or deleted records. So he says, but that on cross, he gets shown up on that. He says that the tabs were later in private, or the tabs could have either been in private browsing mode or the page didn't load completely, and that's why it could have come up as deleted. Also, it could have been user deletion, but he didn't want to admit that. He says that there were multiple records that were deleted, so it wasn't just that record. He says that he can only determine when a record was deleted based on what other records are logged thereafter. The House Long to Die in Cold record was deleted sometime after 10 p.m. on January 31st when Jen turned her phone over to Ellie, law enforcement. That's what I said. So the record was deleted sometime after 10 p.m. on the 31st. He says that at 6:23 and 6:24, the searches were never logged. Since it didn't log, the user had no record to be able to delete it. So here he is covering yet again for Jen McCabe saying, well, since those didn't log, there was no record for the user to delete. So Jen McCabe is innocent and she's a saint and we should all pray to her. Whatever. That's kind of how she's trying to come off on her opening or her on day 6. I'll just say. All right. So where was I? The witness says that this database being used, the data in the database is quote the time last visited. That timestamp information is bad, and ultimately Cellbrite removed that data from their software. And I put a bunch of exclamation points and said, "This is wild." He also, so basically, after this case, they deleted that function of the timestamp from their software because it didn't fit their theory, because it didn't fit the Commonwealth's theory of the case. So the whole company, Cellbrite, just goes and deletes it. Like, what? It's crazy. The witness says that there were thousands of deletions on Jen's phone, so it wasn't just that particular record. Now onto John's phone. The witness looked for location data on John's phone from January 28th through the 29th. He said the application can specify how accurate the location is. So whatever application is being used in the phone is what specifies how accurate GPS or how accurate your location data is. So some apps use GPS, like your Google Maps or your Waze apps or whatever. That's going to use an actual GPS, whereas like your weather app, he said, will just use like an approximate town. So it's not specific. It's not specifically accurate to where you're located. So the app, he's saying whatever app you're using, that's where, it determines how the location is, the level of accuracy for location is how he is wording it. He says that the data is provided with a range of coordinates, so latitude and longitude, and it gives you a range of meters to determine location. It could be as accurate as 2 to 5 meters or several miles, he says. Waze is the highest level of accuracy, and it typically only uses data location while the app is in use. So you're only going to have the highest level of GPS while the app is in use. If you close the app, it might still be doing some things in the background, but it's not going to have the same level of accuracy for location data points. He says also he looked at John's health data regarding taking steps, going up and down stairs. He says a flight climbed as an incline of 3 meters, or a flight climbed, according to Apple, is an incline of 3 meters over 16 steps taken. So he says it doesn't matter if it was stairs, a steep hill, or an escalator, which I find kind of crazy. He says he tested this in a car with his phone. He said, and I said, "How is this allowed?" He says that that if he was holding his phone and waving it around, it would register as going upstairs. If he was going up a hill and waving around and whatever, I don't know what he did because it wasn't a scientific test and he didn't have anything to recreate it or show us what he did. But that's what he kind of explained, and I'm just like, how is that allowed in? Then he also looked for a battery temperature on John's phone, which can be affected by ambient temperature, he says. Again, he did his own tests to determine battery temperature in cold temps. He only mentions this on direct, and he gets crossed on it pretty viciously later on, so it's pretty great. But that's going to be on day 6, right? We're on 5. Why am I confused? We are on day 5. Okay. Where did I leave off now? So John's health data, he looked at the taking steps. Okay, he did all of his own experiments. He says, as iPhone tries to identify a face, when it receives a call, in order to answer it, it will try to engage the camera, but if it's in the pocket, it will register as being in a pocket state. And he looked for this as well as trying to determine John's movements based on pocket states and was it in his pocket or, was it detecting a face? The witness goes over maps showing the location data, which are consistent with the route that Karen and John took to get to 34 Fairview. He pinpoints different, time and different points on the maps. I didn't get into all of the details on that, so apologies. Otherwise we'd be here for days. And then these are supposed to be quicker, but they're not, because I try to give you guys detailed stuff in case you had questions. All right, so he says that the phone never stopped at the address, but it was still traveling, and stops up. Says it stops at the flagpole, so it was still traveling, moving up until it stops at the flagpole, according to this witness. He goes over multiple location points shown on the map with a radius of where the phone could have been located all night. The location shows it's in the front yard near slash overlapping 34 Fairview. He says that someone laying on the phone could affect location accuracy. Shows a bunch of overlapping radiuses that he says all center around the flagpole. But he doesn't explain them, and it's not until cross where we actually learn what they mean. The witness goes over John's Apple Health data, says that data gets aggregated into 10-minute time increments. So you don't know if it says from 12:01 to 12:11 the person took 42 steps, or just, I'm making this up. This is not a real fact of the case. Then those would be any time from, the start of those 11 minutes to the end, or the start of that 10 minutes to the end of the 10 minutes, because it just aggregates. It pulls all the data into 10-minute increments. I don't know. That's what he says. So, next he says there's some of the steps recorded by John, and flights of stairs were recorded while Karen and John were still traveling in the car. So he's saying it's not accurate all the time. They were still traveling in the car, and he had, excuse me, he had steps and flights of stairs that he was climbing, apparently, while in the car. Excuse me. All right. I don't know. I got throat problems apparently today. Allergies, maybe? I don't know. He says that there were no steps or activity that took place from 12:32 to 6:04 a.m. So he's saying that after that time, supposedly that's when John has no movements. The witness plotted out the flights that were climbed on the map to show where each one occurred, and he says they were all while they were still driving, so it didn't make any sense to me. Whiffen says the flights of stairs were more likely from driving on an incline than actually walking up or down stairs. I find that very hard to believe. He says now the witness is telling us over time the clocks in your phone can become inaccurate. And I'm like, what? This has never once happened to me, but that's what he said. Battery temp is constantly monitored throughout the life of the phone. Whiffen goes over John's battery temps, and you can see the link to this spreadsheet is in the comments below, and you can go and link to these other exhibits or screenshots of displays from the trial. He does go over the different times of the night, um, and it is interesting. It does fluctuate. Then he says the average phone temp was around mid 80s, indicating that it was in his pocket most of the night. Temps dropped to 77 Fahrenheit at 12:22 p.m., then 72 Fahrenheit at 12:37. This is after, I'm sorry, that's AM, not PM. This is after Apple Health data stops moving, that the temperature of the battery starts dropping, and after the phone is recovered, temperatures start to increase. You can see on the chart. He also looked at the device usage, the physical interactions with the phone, then he goes over the activity log. So we know that the last interaction with the phone, there's a link to the activity log that you can go look at yourself as well. The last interaction on the phone was at 12:32:09 a.m., where the device is locked by the user by pressing the lock button, according to the witness. Then he goes over a Doppler this is the pocket check, the pocket states, sorry. So he goes, it's called the Doppler report or Doppler records that are used to determine the pocket states. He goes over those so you can see they didn't make a whole lot of sense to me. And then the witness goes over, I mean, it's not very complex. It's just like, I don't know what the point is he's trying to tell us here. And then the witness goes over a timeline that he put together. That I did give you all of the different slides, so you can go over and look at that. Kind of all of the stuff that we've already talked about here, but probably a little more detailed. And then the witness says that the location data shows the phone is around the flagpole area, no health data suggesting it moved other than the 36 steps taken. The battery temp never suggested it went from cold to warm environment, which I disagree, which he says he would expect to see if it was inside 34, if John went inside 34 Fairview Road. He says that it is a consistent pocket state record indicating that the camera was blocked, saying, meaning like he never checked the phone. And he also says that his opinion is that the device never moved from the flagpole area all night. Cross gets started, he has to admit that literally seconds can be significant in cases like this. Alessi revisits Whiffin's timeline. He kind of goes through it with him. Within 2 minutes, two people, Brian Higgins and Jen McCabe, are trying to find out if John is coming to 34 Fairview. Alessi points out details that Whiffen left out in his timeline, such as Brian Higgins' text to John, and the text from Jen McCabe that was read by John. His checking the phone or locking the phone at certain time. Things like that were not all included. There were certain details left out. So he goes through a lot of that. And then he says that the pocket state will only record if camera is blocked in the first place. So you're basically like you must receive a call in your a phone call in your pocket. It- You must receive a call while your phone is in your pocket. And then it'll start, trying to detect a face and it realizes it's in a pocket or blocked. The camera's blocked somehow. And it's going to keep checking for your face. Then, once you pull it out and it starts to recognize your face, it'll go into a status of pocket state cleared. That's the name of what that state is. And then he says it's incorrect to refer to the Apple Health data as Apple Healthcare data, which Brennan kept doing. He consistently says things incorrectly. Um, the jury or Mr. Alessi clarifies that 25 meters, so the 36 steps that John takes is roughly 25 meters according to Apple Health, and Alessi gets the witness to agree that it is actually 84 feet in metric system. And then the witness says there's 7 seconds after the last time John's phone locks when the phone moves 84 feet. So those, so the phone locks, and then there's 7 seconds, and the phone can could continue to be moving for those 84 feet within that 10-minute increment, if that makes sense. So then he gets um tossed till the next day. Not tossed, but his testimony is continued until the next day because there's a ARCA voir dire. So ARCA, Dr. Wolf and Dr. Rentschler go on the stand. As you know, Hank Brennan has been gunning to exclude them from the moment he started on this case. So he went after Dr. Wolf pretty hard. It was pretty disgusting to watch. It was gross. It felt gross. He was incredibly rude. And yeah, so let's get into it. I'll try to go fast through these. It's going to be a little bit faster for him. All right. So he is the director of accident reconstruction for ARCA. He says that he received a court order to produce records in an email from Ms. Little. He says he turned over the records to Ms. Little. He didn't directly email them to the court, which was like some big gotcha moment, according to Hank, but it never happens that way. You're going to coordinate with the lawyer, not the court directly. It was his understanding that it would be passed along to the court. He says that he didn't have any text messages in his possession. He switched mobile carriers at some point. He made efforts to access his records, his previous phone records, but not all of them were available. He got what he could. He says that he turned over around a dozen or so emails that he had with the defense, mainly Mr. Jackson and Ms. Little. He has never communicated with Karen Reed via email. He spoke over the phone with Alan Jackson, Ms. Little, and Mr. Alessi at some point. He had a recent Zoom meeting to go over testing, no Zoom or group conferences before first trial. There was a situation, or this situation, he said, is abnormal at the time because of the federal investigation, which was going on, as of March 2024, I believe they were hired. He went over their normal procedure. So when he was talking to Alan Jackson, he went over their normal procedure, the normal protocol, normal prices, all of the fees, scheduling, all that stuff that he would go over. So that included fees and scheduling at the time, even though they had this understanding that the federal investigation made things unclear. So Jackson had originally reached out about being utilized reached out to Wolf to utilize him as a witness in trial one. He spoke to him like he would speak to anyone else who had considered hiring him as a witness. So he didn't differentiate and say, well, I'm not going to give you pricing because we're under this, you know, government protection order thing. He said then he had to go get, clarification. Things were put on hold until April 2024. Says that he believes he reached out to the Department of Defense, or he reached out to the defense, sorry, after getting clarification from the Department of Justice. And for that matter, the CW could have reached out to them and called them as witnesses, he says. So it was kind of a great moment by Daniel Wolf, who was Dr. Daniel Wolf, who was like, well, you guys could have called me. Hank did not like that answer because then he gets really snarky and asks, so when did you become an advocate for the defense? And he says that he's on the science and analysis, that he's on the side of that, the side of the science and the analysis that he's done. That's the side I'm on. Um, he says that he remembers a couple of brief calls letting Alan Jackson know that he received clarification, one call in early May where he talked about his background and qualifications. So there were early calls in April. He can't remember the specifics. He said he knows he reached out a couple times, to talk about, well, we've got the, clarification from Department of Justice. And then he talked in May for a longer phone call where he went over his background and qualifications. And then Hank tried to do another gotcha moment, like, well, did you talk about, he said he talked about family briefly, chit chat stuff. And he's like, well, did you bill for that? Like, come on, buddy. Whatever. He remembers a couple of calls. He remembers relaying clarification from the Department of Justice. He says that he doesn't specifically remember the April calls and what was exactly discussed. He said the 40-minute call would have been going over his background and qualifications. He never discussed any of his findings with the defense. The witness is a salaried employee. He routinely keeps track of his time. He doesn't get direct compensation when an invoice goes out. That goes to ARCA, not Dan Wolf, he says. So all that money that he, is keeping track of his time and getting billed for, it's being billed to ARCA, not him personally. which again is like an argument that makes no sense why, Hank is really pushing so hard on these guys. He says that he submits his time that he keeps track of so that his boss knows what he's doing. And I kind of laughed about that because, I mean, duh. He says he tracked his time communicating with AJ that went to the Department of Justice, but ultimately the defense paid it later. He doesn't keep track of hours when going over logistics and travel and all those things. So he doesn't track those billing hours when he's just talking about logistics and travel. He says that he provided the full extraction of what was relevant to his communications with the defense regarding this court order. He says that he did delete some texts. He doesn't have a habit of keeping a text chain with clients, attorneys, especially when discussing logistics. And AJ is not his friend, so he wouldn't keep the texts. Texts were over a year ago, maybe around 100 or so. He deleted the text sometime after the trial, probably before he got his new phone. He deletes texts routinely. He believes he only texted AJ from the defense team and no others. Earlier this year, AJ meaning Alan Jackson, said that he preferred using the Signal app. They exchanged a handful of Signal messages, probably 4 or 5. They had a couple Signal calls as well, but he said that the reception was kind of bad, so they didn't use that as much. But this is not I would say this is not outrageous, simply for the fact that the Commonwealth has been trying to go for text messages between the attorneys and Karen and the attorneys and everybody else, like privileged communications. So it doesn't hurt AJ to, have a little bit of protection from the tyrannical Commonwealth. He says earlier this year, AJ preferred Signal, so he started using Signal. It was the only time that he had ever used Signal in his professional career, and he didn't have a problem with it. He said he provided everything that he had in his possession to turn over. There was nothing in his possession regarding Signal, so he doesn't have anything, so he couldn't turn anything over. Never, because Signal is encrypted, it doesn't keep a record, so there's nothing to turn over. He never received a retainer agreement for the first trial. He says they did not have any agreement with the defense regarding compensation for the first time or for costs of travel. He says he had no idea that there even was going to be a bill. As a salary employee, it didn't matter to him who was paying. He didn't know, who was going to get the bill, who was paying the bill. Didn't matter to him. Mr. Jackson spoke with a witness about travel plans, met someone named Kat with the defense. Mr. Jackson told him to park in a church parking lot. Again, this was like some gotcha moment for Hank, but it was a nothing burger. He believes that the first time he actually met Alan Jackson was when he arrived for the first trial. He did not have a conversation with the defense about the case. He communicated with Alan Jackson in June, but never talked about the case. Everything was logistics. Vaudier was June 18th. He testified on June 24th. Again, he says that he did not talk to anyone about the case. Hank Brennan shows him an email Daniel Wolf sent to AJ the night before his testimony in trial one, along with an attachment of questions. It was more of an outline. I put questions, but he referred to it as an outline, so I should fix that. But it was an outline that he suggested or gave to Alan Jackson with his email, basically just following up like here, I'm looking forward to testifying. Here's some information for you. The witness says that he never spoke with AJ about any of what he mentioned in his email or attachment. Says what he sent to AJ was what he routinely sends to help himself prepare for trial. The witness says he assumed Jackson was ready, or he assumed Jackson already had his questions prepared for his direct. He says that the questions are more for him to prepare and to help the jury better understand his testimony. The outline he sent would have been sent to the Commonwealth as well if the Commonwealth had reached out to him. So he dug at them one more time to say, You know what? You guys could have hired us, but you didn't. He says it's to assist the jury. The witness confirms the Department of Justice was closely watching the first trial and they had direct line of communication with them about the trial, which I found very interesting. So the Department of Justice was watching the trial closely, trial number one, and they were going back to Dr. Wolf and Dr. Rentschler and telling them what was going on in the trial, which I find fascinating. Um, and then he said he had provided everything he had in his possession. Now on cross, Alessi admits court order to ARCA for communications had witness he admits the exhibit, sorry. Alessi admits the exhibit of the court order to the ARCA for their communications, and he has the witness confirm that that's what he received. The witness reads from the order, quote, all records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related any way to billing, payment, compensation, and/or reimbursement of any kind in connection with the Commonwealth versus Karen Reed. He says that he and everyone within ARCA has turned over everything requested and is in compliance of the court order. He says that ARCA, under contract of the Department of Justice, an internal ARCA ARCA billed. I'm missing a word there. ARCA billed under the contract with the Department of Justice an internal number that was assigned to the contract number. The witness says that the project number originally assigned remained the same the whole time. Under the contract number, the time was going to be billed to the U.S. government. That was his assumption, never anything else. He never had any understanding that there would be a bill to the defense team. The final report from ARCA was issued February 2024, no changes. Conclusions have remained the same since February 2024. The defense never had any conversations with ARCA about the substance of the report. He had no conversations with the defense about the report to the Department of Justice. That's their big long report that they submitted. The defense never asked them to change anything in the report. In 2024, the DOJ prevented them from having any other formal agreements, such as retainers, etc. So everything was still under the contract with the DOJ. In March 2024, there were no inducements, offers, or payments, signed retainers, or any assumption that ARCA would be compensated by the defense. He never had any discussion of any kind with the defense regarding the invoice sent in July after the trial. The witness says that he had nothing to do with the billing or sending invoices, so he didn't even know who it was going to, what was getting billed. When he made specific entries regarding his time, he had no idea that it would be billed to the defense. It was all under the DOJ. He never believed that he was retained by the defense at any time. In fact, it was prohibited by the DOJ. After Wolf sent the pause email, the DOJ took a while to determine what they could do, how they could proceed. Wolf wasn't even sure if they would be able to testify. From 2023 up until the trial concluded, everything was being billed to the DOJ project. His retainer email was describing their typical protocol, but they had communicated under the assumption that they needed clarification on how to proceed from the DOJ. There was no substantive conversations with the defense about a report to the DOJ. A lot of phone tag was happening, or he was coordinating his and Dr. Rentschler's testimony and, travel, things like that. So he was trying to coordinate the two of them at the same time. So he said there was a lot of phone tag going back and forth. Previous conversations were about figuring out how to proceed with the DOJ, then him going over his background, then shorter calls discussing logistics. Due to the unique nature of the federal investigation, he had to have more conversations. There were more conversations needed because you had to clarify things and you had to, get, I'm sure there were questions and things that needed to be discussed. So there's that. AJ never asked the witness for a list of questions. He thought it was important to the witness to help the jury understand the analysis and his report. So that's why he sent the outline to AJ. The defense never asked him to communicate anything in his report in any way. Wolf's comments in his emails to AJ were to help the jury better understand. He wasn't trying to help either side. He wasn't shying away from a statistic. He actually testified to it. So they were trying to make it seem like he was, keeping stuff from the jury, but he wasn't. It says that he testified without any conversations to the defense about the substance of his testimony. He doesn't recall any member of the CW about compensation, about talking about, he doesn't remember any member of the CW about compensation by the defense or having conversations with the defense. I don't know what I said there, what I meant there. You guys do. That's good for you. At the end of the trial, the witness had no idea the defense would be invoiced, and the defense never stated that they would be compensating them for anything. They only had communications with the defense where there was a text after the trial. So since the trial, the only communication he had with AJ was AJ sending him a text saying, "Thank you for your testimony." That was after the trial concluded. He didn't know that there even was an invoice that was paid. He didn't even know there was one sent. He says the first communication in 2025 was a 30-minute phone call in February. He says he received a bit of harassment since there had been motions to exclude ARCA around that time. That's why he reached out to the defense. He didn't know why he was getting harassed. He assumed it was because people weren't happy about his testimony or something. He was receiving negative comments. He He has done his best to provide truthful and accurate information in this case. After February 13th, AJ said he preferred using Signal. He didn't mind using it. He never used Signal before, but he didn't think that there was anything wrong with it. There was never anything inappropriate discussed in those Signal messages, he says. The witness reached out to the U.S. Department of Justice around March 15th through the 18th. He says new accident reconstructionists retained by the CW turned over about a one-page report and a PowerPoint presentation. The witness says none of the information in the report was helpful in being able to respond. It didn't paint a full picture. He says he would not have been able to respond or provide an appropriate response without more information. They were officially retained by the defense March 26th. His office sent over links to discovery. They had to expedite the work because time was short. They had to put work and personal things aside in order to work in this case. He would have liked more time, but worked as quickly as they could to complete the testing. All testing is a response to Dr. Welcher's work. He needed Welcher's info clarified before he could start working. He believes that he can conclude all of his testing and analysis by May 7th. And that is the end of, oh no, I'm sorry. That's not the end. That's the end of Cross. Hank Brennan comes back and does a little redirect, and it's pretty awful again. So he gets Dr. Wolf to admit that he hasn't provided any reports. He did not know when the CW, regarding the new testing. He says he did not know when the CW turned over their report for this Dr. Welcher. So he needed to get the Dr. Welcher stuff in order to respond to it. So that's what we're talking about here. He says that he could have testing and analysis done in a month or more. He says DOJ was giving them info about the trial, in particular the accident reconstructionist. So I think the DOJ was laughing at Trooper Paul. He says that he never shared any info that he received from the DOJ to the defense. The DOJ relayed the Commonwealth's theory of the arm being hit and about DNA being found on the bumper. Those are the only things that he could like remember off the top of his head. He said all communication and work product is protected, classified by the DOJ. And then Bev shuts Hank Brennan down by calling a sidebar and says, when they return, she excuses Dr. Wolf and says, very quick with Dr. Rentschler here. So Dr. Rentschler is called. He is the senior biomechanist um, for ARCA. He communicated with the defense since before testimony in the last trial, maybe 6 text messages, he says, and just a couple of phone calls. He remembers only speaking about background or his qualifications. ARCA doesn't have any specific policy to retain records, so he didn't keep any texts or anything like that. He didn't know that there was a sequestration order. The only he only met with the defense at the also on that sequestration order. Usually, experts are excluded from that because you're allowed to watch the other experts' testimony in a trial and opine on it. So, anyways, and then he says that he only met the defense at his first voir dire after testimony provided a ride to the airport by somebody from the defense, and there was a lunch with the family at some point after his testimony. He kind of ate, sat in the corner, whatever. But like that was his only interactions with them. Bev then asked, so like she cut him off. She cut Hank off from his direct and says, um, if he was able to produce before May 7th, if she ordered it, would he be able to? He said, well, if you order it, we will try. I just kind of LOL'd at that. It's like, well, if you order it, it's got to be done, right? And then Bev excused him, and there was no opportunity for the defense to cross. But no worries, because at the very end of day 6, she allows the each side to argue. Well, actually, she didn't. She allowed Hank Brennan about 10 minutes to argue, and then she cut Alessi off during his arguments and said, I'm going to side with you. You're going to win. And then she's like, the defense has a right to put on a defense. And so she denied the motion. The ARC witnesses are coming in, which is great. And she did say that she will give, a lot of leeway to Hank Brennan and his cross when they are called in the defense's case, but at least hopefully he won't be so rude in front of an actual jury. We'll see. Because if a jury sees that, they're not going to like him. He was very, very unlikable. Just some very, very nice gentlemen who are like extreme professionals and they didn't lose their cool. They were really good. So, that is the summary, the recap of day 5. Sorry this one was long, but I wanted to give you the specifics because it was techie stuff, especially for Whiffen. So I wanted to give you guys detailed notes on that. So not all of the witnesses will be this detailed, but when it's really important stuff, I want to give you guys the specific deets. So there you go. There you have it. And for the next day, we will get into Ian Whiffen starts out fresh the next day for day 6, and then Jen McCabe is called to the stand. So that's an interesting day. So we will get to that in the next episode. Thank you guys so much for watching. Take care. Bye now.